Hi, my name's Carolina, and I'm a paralegal in the Human Right to Housing Project at the Public Justice Center. I'm here to give a really brief overview of the rights of tenants here in Baltimore City. One thing I want to say before we get started is that if you are facing a specific problem with your landlord, whether that's eviction or repairs that the landlord's not making, please seek legal advice. You're welcome to give Public Justice Center a call, and there are lots of other organizations that offer advice and sometimes free representation to tenants with problems with their landlord. I want to start off by talking about evictions. Evictions cannot take place in Maryland without going through a judicial process first. So a landlord can't just throw out a tenant, even if that tenant is behind on rent. They need to take the tenant to court. And a tenant will have an opportunity to defend themselves in court. That's the case even if that tenant doesn't have lawful immigration status in the United States. It's the case even if there's no formal written lease agreement. The tenant still has the right to defend themselves. The most common kind of eviction case is a failure to pay rent case. And the landlord initiates that kind of case by going to court and filling out a complaint. And that complaint says how much they say the tenant owes. And a tenant finds out about it in the mail and in a mailing from the court itself. They'll receive notice in the mail from the District Court of Maryland. They'll also receive a notice posted on their door. A tenant should open that kind of mail as soon as possible because those cases tend to come up very quickly. They should also read through the complaint really carefully to make sure they understand what it's saying, when their court date is, and how much the landlord is saying is due and owing. If tenants want to defend themselves, they need to make sure that they're present at the court date. Some defenses that they could raise have to do with the amount. So do they actually owe? How much the landlord is saying that they owe? They can also raise defenses related to the condition of the property. And there are some more technical defenses related to property registration and licensing and lead registration. If you have more questions about that, give the Public Justice Center a call and we can talk about it more. If the landlord wins the case, they can proceed to the next step of the eviction process. In almost all failure to pay rent cases, the tenant has the right to pay and stay. If they can come up with the money for the judgment amount plus court costs before the date of the eviction is canceled. In Baltimore City, for failure to pay rent cases only, tenants are entitled to a notice of eviction date by mail that's sent 14 days before the date of an eviction and posted on their door 7 days before the date of the eviction. Again, that's only in Baltimore City and only for certain kinds of eviction cases. There are other kinds of eviction cases, and unlike a failure to pay rent case, they don't originate with the landlord filing a court complaint. They originate with the landlord sending the tenant a letter asking them to leave. A landlord can send a letter to the tenant asking them to leave because their lease is coming to a close, or let's say they're a month-to-month renter and the landlord just asks them to leave. I'm terminating your lease. In Baltimore City, a month-to-month renter is entitled to a 60-day notice to terminate the lease. After those 60 days are up, if the tenant is still in the property, the landlord can't just throw them out on the street. They have to take them to court in what's called a tenant holding over case. And tenants can raise defenses at that kind of case too. If they disagree that they might say they never received the notice, or they didn't get enough time. They might say it's retaliation. If you're facing this kind of action, again, please seek legal assistance before your court date. Another kind of eviction that's initiated by the landlord sending a letter to the tenant is what's called a breach of lease eviction case. A landlord sends a letter to the tenant saying, "You're breaking your lease, please move out in 30 days. Landlord can also say, "Please move out in 14 days if the activity that the tenant's doing is considered dangerous. In either case, on day 15 or day 31, the landlord can't just throw the tenant out. They need to file a breach of lease action in court, and the tenant has the opportunity to defend themselves. And once again, if you are facing that kind of case, please seek legal advice before your court date, and potentially even as soon as you get that breach of lease letter, particularly for renters who live in subsidized buildings. There may be sort of an extra layer of protection or an extra administrative process that you can take advantage of before you even have to go to court. One last thing I want to talk about before I go is the right of renters to a safe and healthy home. Sometimes the landlords do not maintain the properties, and if a tenant is dealing with that kind of problem, they do have rights to a safe and healthy home. One thing that a tenant can always do is just call their city or their county Department of Housing and ask for an inspection. Tenants also can use the rent court to sue their landlord to make repairs in the property. That process is called rent escrow. If you're interested in that kind of case, if you want to find out more or understand your rights or your options, if your landlord isn't making repairs, please call Public Justice Center or call another organization to find out more about your rights. Thank you so much for listening. Have a good rest of your day.